lecturer in public law at the University of Glasgow, whose work was cited by the Supreme Court in yesterday's judgment. He joins us now. Michael, good morning.
Good morning, Rosie.
There has been lots of confusion in this area for years now that the Supreme Court sought to clarify yesterday. In real layman's terms, can you explain what their ruling yesterday means?
So, I think this has been summarised quite well. The central takeaway point from the Supreme Court's ruling yesterday is that for our anti-discrimination law, any reference to sex or to woman or to man references biological categories, not self-identified categories or legal certificated categories. And that's going to have an impact on the operation of all of the anti-discrimination law that deals with things like single-sex spaces, toilets, changing rooms, prisons, sport, areas that are covered by our anti-discrimination law. It's now clear that when they reference sex, they reference biological sex.
OK. And so the part of the reason we needed this clarification was there had been confusion around what legal rights a gender recognition certificate actually gave you. As far as your understanding, what does that change for you now if you have that certificate?
So the central change that a gender recognition certificate provides for anybody who acquires one is that they will be recognised in the eyes of the state as being of the acquired gender that they have on this certificate. For areas where the Gender Recognition Act applies. And most of those areas will be things that predominantly concern the interaction between the individual and the state. So it will be things like the records of your birth certificate or marriage certificates or death certificates, but it won't automatically apply to areas that come up against the rights of other people, which are ordinarily dealt with within our anti-discrimination law. So it's predominantly governing the relationship that an individual now has with the state. There will be other areas where it's not perfectly clear what a Gender Recognition Act provides, but the Supreme Court has now provided us with a test that we can rely on to identify that in future cases. But we know for certain that it doesn't apply to the Equality Act or to anti-discrimination protections that we have. And that doesn't mean that transgender people's anti-discrimination rights have been taken away. It means that their rights are protected separately from the characteristic of sex. And transgender people will have a biological sex as well, which they may face discrimination on the basis of, or on the basis that they are perceived to be a member of one biological sex or another, and they retain those protections in our law.
OK, we're going to get on to transgender protections in a moment or two. The thing that I think has caused confusion and maybe businesses are thinking about today is that now, my understanding, it is lawful to exclude biological males from female-only services. So what are those services and what obligations are there then? Let's say you are a business owner that has toilets or that has changing rooms like a gym. What obligations are you now under?
Yeah, this is a really important point. I think it should be said that this ruling doesn't radically alter the law in that area. It's always been lawful to operate single-sex spaces on the basis of biological sex. It's just much clearer now that that is something that service providers are entitled under law to do, where we're talking about the ordinary, everyday, single-sex spaces that exist in order to protect the privacy and dignity and safety of women and girls. So these are things like gym changing rooms or toilets in pubs or rape crisis centres or things like that. And so the consequence of this, I suppose, the consequence of this ruling is that it is now crystal clear that they are lawful to be provided. But I think it's also important to note that failure to provide these services in some contexts could also amount to unlawful sex discrimination against women and girls. And that is something that we're seeing work its way through several tribunal cases at the moment. And people will be familiar with the case of Sandy Peggy and NHS Fife. And that is going to be something that we're going to see work its way through the court system as well.
So if you are, let's say, a business owner that provides changing rooms for a gym and you've got female changing rooms and male changing rooms, do you now need to provide a third changing room?
I think you can provide a third changing room, and I think it would be advisable to do so. It certainly would not be advisable to label your changing rooms male and female and to operate them on a presumption that doesn't map onto the category of biological sex, because the protections and the exceptions that exist in the Equality Act, which allow you to have separate sex facilities, are now clearly understood to be based on biological sex. And so it may be the case that it would be inappropriate to demand, require, or expect certain transgender individuals to use the facilities that are associated with their sex. And so in that case, it would be prudent, I think, to offer alternative third spaces that could be used by them in order to avoid any disadvantage that they might experience.
I mean, there are going to be some businesses today thinking, gosh, they've got to try and weave their way through this, desperately keen not to offend or upset anybody, but also not to breach the law. I think listening to that, you might think, well, if I'm transgender, I do feel like my rights have been eroded. I was allowed to do things yesterday that it's going to be more complicated for me to do today. But the Supreme Court was clear to say that this hasn't removed protection for transgender people.
Yes, that's right. And, I feel some sympathy for people who have been operating under legally false presumptions about what their entitlements are. And a lot of these people have been relying on campaign organizations and in some cases even lawyers who have told them that they are entitled to use single-sex spaces on the basis of either self-identification or certification in the form of a gender recognition certificate. That is not legally correct. I think that several lawyers have said that that is not legally correct for years. And now we have the Supreme Court confirming unequivocally that that's not legally correct. But you can understand people who have been operating under this false presumption for years are going to think and feel that the clarification that this was a false presumption is going to look like rights have been taken away from them. But the only response that we can have in terms of the law here is to say those rights didn't exist in the first place. These were things that people thought they had as a result of campaigning groups misrepresenting the law. And now we have clarity.
What businesses, I think, are lacking is clarity. And we actually struggled when we spoke to the health minister earlier to answer that question about, for example, which changing room a transgender person should be using. Businesses are going to have to try and work that out. The other question that's come up quite a lot is we're talking a lot about the rights of women. Is it fair to assume that the rights of biological men would also have the same rights as women?
Yes, sorry. I mean, it should be clarified that what the Supreme Court decided on yesterday was the meaning of the term sex, man, and woman in the Equality Act. And they are all tied to biology now. We understand that clearly. I think the reason why people have been focusing on the question of, what is a woman and how do women's rights interact with gender reassignment is because that's where most of the conflicts of rights have occurred in the course of the last decade or so. And that is because of the particular ways in which the unique vulnerabilities of women have given rise to distinct potential conflicts of rights. But as a matter of law, this applies across the board to women and men.
Thank you so much for just going in quite some detail and depth through many of the questions that have been sort of risen as a result of this ruling yesterday. That's Dr. Michael Foran, a lecturer in public law at the University of Glasgow. Thank you so much.
Hopefully that helps to